Thanks, Tom. I'm here today to explain about 3 issues as it's pertaining to the gainful employment litigation. First, as Tom mentioned, the CBO scoring of the gainful employment regulations as it pertains to an argument that APSCU brought up during their May 20th oral arguments. Specifically, APSCU contended that many students would not be able to continue their education at any school if their programs were to lose Title IV eligibility. They were saying that other programs in that school would not be able to pick them up. They were saying that other local schools would not be able to enroll them. Meanwhile, the department was saying that no, yes, other schools and other programs in the area would be able to absorb these students who could not continue their education at their initial institution of higher education. Of course, the CBO came out with their scoring, and what that alludes to say is that the department is already assuming and almost banking on, if you pardon the pun, that these students will be out of the Title IV eligibility, therefore creating that excess money. And that, again, that is a direct conflict to what the department was claiming in the oral arguments. So again, they're saying that no, these students will be continuing their education somewhere, but by the same token, that excess money will be there, which would indicate that no, these students will be out of Title IV funding. So the department's kind of talking on both sides of their mouth. Secondly, I want to bring up some of the updates in terms of the higher education reauthorization, as well as the the House Labor HHS and Education Appropriations Bill. As Tom mentioned, both bills have their own provisions that will defund or stop or otherwise attack, if you will, in a legislative sense, gainful employment regulations. This is important because the department relies upon the statutory ambiguity of the Higher Education Act. Specifically, that ambiguity, that congressional ambiguity in the statutory language, means that the department has the ability to interpret what they reasonably think that Congress would have wanted. Should these provisions go through, that is to say that these provisions to block gainful employment or defund it, that would show congressional intent per a Chevron analysis, which is basically the major lead case that courts would consider when it looks to statutory intent and statutory authorization. So again, if Congress speaks on the matter directly, then the department has no opportunity to interpret. But if there is the ambiguity, then the department can act. So hopefully these 2 provisions in the higher education reauthorization, as well as the labor HHS appropriations bill, will say no, Congress doesn't want gainful employment. That would give Judge Bates an opportunity to say, well, there, Congress has spoken directly on the issue. That then says that could destroy, and a key word being could, destroy the argument that the department presents that, hey, we can do this. And I say could because this could be a matter of statutory interpretation, or I'm sorry, a matter of judicial first impression. And somebody like Judge Bates, he could like the opportunity to write a new law or write a new case, if you will. So basically what's going on is under that Chevron analysis, congressional intent typically has always meant that both the House and the Senate pass their bills in identical fashion, and then that the president will enact the law by his signature. Obviously, we don't think that this is going to happen, that being that the president won't sign this bill that would undermine his or vacate his regulation or proposed regulation. So what some lawyers and what some legal theorists would argue is that even though the House and the Senate might not be speaking uniformly in terms of saying the same exact language and passing the same exact language, they are passing very similar bills which say the same thing in different words, but they say the same thing, they do the same thing, and they want to stop the same thing. So if the Senate passes their bill and the House passes their bill, that could be considered congressional intent. And again, Chevron analysis only says Congress. It doesn't say Congress and the President, it just says Congress. So there's a lot of moving parts here. There's going to be a lot of judicial opinions, and unfortunately none of them are going to matter unless it's Judge Bates, but there's going to be competing opinions as to what would imply congressional intent. So where does that leave us right now? Well, here on June 19th, Judge Bates still hasn't ruled yet. Personally, I think that's a good thing. It could indicate that he's actually considering what is going on up on the Hill. It could mean that he is looking to see maybe Congress does speak directly on the issue. If that means that gainful employment is not funded in the appropriations bill from the House that has originated in the House, or if that means that the Senate higher education reauthorization will block it, that means that he doesn't have to rule. He doesn't have to be the bad guy. In terms of APC, we are now almost a month into their allotted 60 days, which they have been allotted for a possibility of appeal. To date, they have not filed any appeal. It's my belief that they're kind of waiting on Judge Bates to see what happens. Hopefully, Judge Bates comes down in our favor, and APC does not need to pursue a additional claim of appeal. Again, as before, we will keep a close eye on all developments, both on the Hill and in the courts, and we will provide everyone with summaries and explanations, emails, and videos once more information is available. Until then, have a great day.